Especially on paragraph 10, when it reads as follows. When the two accused persons appeared for the initial appearance at the Magistrates Court on the 26th of June 2024, they were coming from home and they were not at any point incarcerated prior to the initial appearance. Neither will they put in detention or have their liberty restrained. That's paragraph 10 of the filed statement of agreed facts. Yes. My Lord, the question on the procedure that is to be adopted when an accused person appears in court and they are coming from their home is an issue that has already been decided by the Supreme Court, rather the Constitutional Court.
There is a judgment of Kenny Murray versus Donald Ndurowe and others. Constitutional Court number 2 of 2007. Number 7, Constitutional Court number 2 of 2007. My Lord, in that judgment, the court deals extensively and then held that where it is clear that an accused person is coming from home and has not been detained by the police, he or she should simply appear in court and then released to the next remand state. The issues of bail do not even arise under those circumstances. In fact, the ratio dissident in that case is that to arrest, or rather to place such a person in detention amounts to deprivation of liberty, as enshrined in Section 49, subsection 1B of the Constitution. My Lord, if one looks at the facts of this case, as evidence was laid from the accused persons, as well as the facts contained in the statement of agreed facts, you realize, my Lord, that at some point the accused persons, in the company of their legal practitioners, were summoned to the Zimbabwe Anti-Corruption. They appeared.
It's part of the statement of the facts.
Yes, ma'am. It is on paragraph, the court may just be with me. Paragraph 8, my lord. It reads as follows. Moses Mpofu and Mike Chimombe returned to Zimbabwe from China on the 20th of June 2024. They attended to the Zimbabwe corruption offices in the company of their lawyers on the 24th of June 2024, and they were then excused. And then paragraph 9 says, Moses Mpofu and Mike Chimombe returned to the Zimbabwe corruption offices on the 26th of June 2024, and they were advised that they were facing allegations of fraud related to the gold scheme, and that they were to appear in court on the very same day. So the point I make, my lord, is that the facts are clear that on the 24th of June, there was an appearance at the Zimbabwe Anti-Corruption Commission, and the accused persons were then excused. And then on the 26th of June 2024, they then appeared at the Zimbabwe Anti-Corruption Commission offices while they were coming from home. That is when they were then advised that they were to appear in court on that very same date. And when they appeared, as per the authority in Ken Murray versus Donald Nduro and others, they ought to have been treated they ought not to have been treated in the manner that they were treated, wherein they were then incarcerated. My lord, what is of interest is what is then dealt by the Constitutional Court in Ken Murray versus Donald Nduro and others. It refers to a judgment that had been made in Muzondo versus Minister of Home Affairs. It's 1993, Volume 1, Zimbabwe Law Reports. Muzondo versus Minister of Home Affairs. In another, that's judgment 1993, my lord, Volume 1, Zimbabwe Law Reports. It's page 92. It's a Supreme Court judgment, but the Supreme Court was sitting as a constitutional court in terms of the old constitution. That case, my lord, illustrates the factors that ought to be considered when an accused person is to be incarcerated. And it makes it clear that there are three factors that must be considered. And these are they. Number one, whether or not there is a possibility of escaping. Number two, the prevention of further crime. Number three, the obstruction of police inquiry. The point we make, my lord, is that if one looks at the factors as per Muzondo case, they are clear and illustrate that there is no justification as to the reason why the two accused persons were then deprived of their liberty. by being incarcerated. There was no legal justification for the deprivation of liberty. And my lord, what is clear is that their rights in terms of Section 50, subsection 1, that is 1D, which says that any person who is arrested, then 1D says, must be released unconditionally or on reasonable conditions pending a charge or a trial unless there are compelling reasons justifying their continued detention. So the point that we make, my lord, is that there were no reasons. In fact, the issues of bail ought not to have arisen. And that their detention was therefore a violation of their rights as enshrined in Section 49 of the Constitution. My lord, those would be our submissions in support of that ground. With your leave.
You are saying what would be the remedy?
The remedy under the circumstances.
I read the complaints and what would be the remedy in the event that there was a violation or infringement of bankman-fried as enshrined in Section 51 by the magistrate who denied them there?
My lord, the application before you is wherein the accused persons are seeking a referral, that such rights have been violated, and they seek the intervention of the Constitutional Court.
I want to know what remedy they will be seeking vis-a-vis these proceedings.
My lord, I don't seem to follow the question, but nonetheless, my lord, there is a prayer in the request for referral wherein the accused persons are seeking permanent stay of prosecution as a result of various rights being violated.
So you are connecting that to the prayer for
Yes, ma'am. Thank you, my lord. My lord, I will move to the second or the other ground, which is K. And it reads as follows: whether their selective prosecution in respect of these cherry-picked charges not being instigated in the quest of justice, but as a punishment being meted out wrongly on the accused persons by certain individuals who believe incorrectly that the accused persons are responsible for leaking certain texts, audios, pictures, and videos, wherein one witness, Chivayo, is seen and heard discussing about how he intended to bribe certain government officials, and the total disregard of other charges, the basis upon which the current charges were instigated amounts to a violation of their rights to equal protection and the benefit of the law as enshrined in Section 56, subsection 1 of the Constitution of Zimbabwe. My Lord, the facts are very simple, and I will refer you to the statement of agreed facts to illustrate clearly the point that is being made by accused persons. And I'll start on paragraph 4, and it reads as follows. On the 16th of June 2024, the chairperson of the Zimbabwe Anti-Corruption Commission, Honorable Ms. Pereza, conducted a press conference wherein he indicated that the Zimbabwe Anti-Corruption wanted to interview Mpofu, Chimombe, and Jurisdictional concerning audios that had been leaked and invited the trio for interview. Paragraph 5 says, on the 16th of June 2024, ZAC released a press statement in which the Zimbabwe Anti-Corruption invited Mpofu, Chimombe, and Jurisdictional concerning audios, recordings, as well as letters which raise issues to do with money laundering and abuse of office, as well as the presidential board scheme. Paragraph 6 says, Mpofu and Chimombe were in China when the press statement as well as the audios were released by the Zimbabwe Anti-Corruption. On the 17th of June 2024, they addressed a letter to the Zimbabwe Anti-Corruption through their lawyers, Antonio Duterre Company, expressing their willingness to cooperate with the Zimbabwe Anti-Corruption. Paragraph 7 says, Jurisdictional never presented himself for the interviews at the Zimbabwe Anti-Corruption Commission up to date. My Lord, the facts that I have just read, they illustrate that certain audio recordings were leaked, certain written documents were leaked. In those recordings or in those writings which were leaked, they were of interest to the Zimbabwe Anti-Corruption. And the reason why they were of interest to the Zimbabwe Anti-Corruption is because they tended to show that certain offenses had been committed. They had to do with money laundering, they had to do with the bribing of public officials. In essence, it had to do with corruption, as well as the vote scheme, the presidential vote scheme, which is what has brought these accused persons before you on these charges. But what is of importance, my Lord, is for this court to take note of the fact that the current charges that the accused persons are facing emanated from certain recordings or from certain letters that were leaked, which then instigated investigations by the Zimbabwe Anti-Corruption. In other words, these audio recordings and certain letters, if they not been leaked or if they not become public knowledge, we would not have been here, my Lord. The complaint by the accused persons is that there is selective prosecution by the Zimbabwe Anti-Corruption, which is not only failing to do its duties in terms of the Constitution, but actively protecting Mr. Jurisdictional. I'll refer you to the Constitution of Zimbabwe. Now, I want to deal first with the duties of the Zimbabwe Anti-Corruption, the Zimbabwe Anti-Corruption Commission. Section 254 established the Zimbabwe Anti-Corruption Commission, and then Section 255 then deals with the functions of the Zimbabwe Anti-Corruption Commission. And here is what it says there. The Zimbabwe Anti-Corruption Commission has the following functions. A, to investigate, expose cases of corruption in the public and private sectors.
Very well. Mr. Mge, you can proceed.
Thank you, my lord. I've lost my steam. I'm not so sure where I was with submissions, but I will endeavor to proceed.
You were discussing the functions of the Anti-Corruption Commission in terms of Section 255 of the Constitution.
Thank you, my lord. My lord, the Constitution reads as follows. The Zimbabwe Anti-Corruption Commission has the following functions: to investigate and expose cases of corruption in the public and private sectors. B, to combat corruption, theft, misappropriation, abuse of power, and other improper conduct in the public and private sectors. To promote honest financial discipline and transparency in the public and private sectors. D, to receive, consider complaints from the public and to take such actions regarding to the complaints as it considers appropriate. To direct Commissioner General of Police to investigate cases of suspected corruption and to report to the Commission on the results of any such investigations. To refer matters to the National Prosecuting Authority for prosecution. But what is of importance, my lord, for the point that I'm making is Section 255 1D as well as 1F, which enjoins the Zimbabwe Anti-Corruption Commission to consider, to receive and consider complaints and to take such actions as may be appropriate, as well as to refer matters to the National Prosecuting Authority for prosecution. My lord, the right to equal protection of the law and benefit of the law includes the right to benefit from due process of the law. And that everyone must be subjected to due process without fear or favor. My lord, the case of Trangirai versus the Registrar General and others, 2002, Volume 1, Zimbabwe Law Reports, at page 268, makes that point. The point that I'm making, my lord, is that once there was certain information at the disposal of the Zimbabwe Anti-Corruption, that there are certain audios and certain letters in which a certain individual spoke of bribing public officers, spoke of money laundering, spoke of criminal abuse of office by public officials. The Zimbabwe Anti-Corruption is duty-bound to investigate such allegations.
You said information regarding bribing certain officials?
Involving the bribing of certain public officials, money laundering, as well as criminal abuse by public officials. The Zimbabwe Anti-Corruption Commission is duty-bound to investigate such issues. And my lord, it appears that from the onset, the Zimbabwe Anti-Corruption was alive to this. Because in the interviews that were done by its chairperson as well as the press statement released, they indeed invited those that they thought could assist them in such investigations. But what is clear, my lord, is that up to date, the accused persons are only before you regarding the presidential goat scheme. The other case has disappeared into thin air.
You mean the other cases against your clients?
Yes, my lord.
You want them to be... You are... What are you saying?
What I'm saying, my lord, is that when certain audios... And
no, I'm clear. You are concerned that your clients have not been interviewed regarding the other cases?
There has not been an investigation
of those other cases.
Of those other cases. And our point, my lord, is that our clients, the accused persons, are critical for those other cases. Whether or not ZEC, the Zimbabwe Anti-Corruption, will formulate an opinion of them being accused persons or being witnesses is something else. But the failure is what we are complaining about. The failure to investigate, the total turning of a blind eye by the Zimbabwe Anti-Corruption to those issues is what is wrong and is what constitutes a violation of our clients' rights to the equal protection and benefit of the law. My lord, it is an agreed fact that when the invitations were done, our clients, the accused persons, conducted themselves as law-abiding citizens. They submitted themselves to a constitutionally made board by willingly going for interviews. It is again an agreed fact that one of the persons who had been invited never went for those interviews up to date. The impression and the conclusion that can be drawn from such issues is that there is selective prosecution and that the Zimbabwe Anti-Corruption is failing to do its duties, or in an extreme case, they are protecting someone. That is the conclusion that can be drawn from those facts. My lord, we must not lose sight that the Zimbabwe Anti-Corruption, in its own right, now has powers to arrest. I think it's SI 143 of 2029, which empowered them.
2029?
Yes. 2019. Sorry, my lord. 2019. SI 143 of 2019. That statutory instrument amended Section 25 of the Criminal Procedure and Evidence and designated officials from the Zimbabwe Anti-Corruption as peace officers who could effect arrests. My lord, in the press conference that the Zimbabwe Anti-Corruption chairperson gave, he not only does he invite the three named individuals for interviews, he in fact then says, if they do not subject themselves...
Is that part of the evidence?
My Lord, I withdraw it. I withdraw it.
Okay.
But nonetheless, the point I make, my Lord, is that if one is to have regard to the case of the Commissioner General of Police versus Renford and another, 1984, Volume 1, Zimbabwe Law Reports, at page 202. In that case, it was held that members of the police may not, in the exercise of their duties, refuse to perform or neglect to perform duties that are empowered to them by the law. And that failure to perform any duties on the part of the police may result in individuals' rights to the protection of the law being violated. Whilst that case dealt with the conduct of the police, it is my submission that the case applies with equal force to the Zimbabwe Anti-Corruption Commission, which has powers to investigate corruption as well as to arrest those that they think would have violated the law. My Lord, those would be my submissions on that point.
And you are connecting that to which relief? What then? I just want to understand the relevance of that to this case, and what relief is connected to that.
The relief that the accused persons are seeking is that of permanent stay, my Lord. My Lord, they believe that in as far as the totality of their case is concerned, they are being persecuted, and that the Zimbabwe Anti-Corruption is failing in its duties to properly apply the law.
Yes, maybe I'm not making myself clear. I'm not saying that the relief will be sought in this court. I know this is a request for referral, but I want to understand how the constitutional issues affect this case. That is that is what I'm concerned about. There was reference here. In other words, they are saying that they must not be prosecuted before that other case is not prosecuted or is investigated. I want to be very clear about how the other case you have alluded to, or the other, those facts giving rise to a suspicion that an offense, how do they impact on this case which is before us?
I hear you, my Lord.
Yes, and that is exactly the question. That is exactly my interest, even when regarding the. Maybe it's clear with the alien, but with this case, maybe you assist me.
I hear you, my Lord. My Lord, the accused persons, to address you directly, they are not complaining that they ought to be someone else with them in the dock as they sit.
That is clear from their answers to the questions put to them by the prosecutor. So I want to understand how you are tying the relevance of that complaint to the case before us?
My lord, the relevance is that any person must be accorded equal rights.
No, I understand. That obviously would be. I don't wish to delve into that. I'm more concerned about the impact or the connection between that case and the matter that is before us for trial.
My lord, the issue really is about where is a person then entitled to raise those issues. If they feel that their rights are being
You obviously
violated.
wouldn't be asking me that.
No, my lord. I'm addressing.
I just want to know. I'm sure my question is clear enough. Why should this court be concerned about those other matters? We convened to deal with a criminal trial.
Yes, my
We're
lord.
dealing with specific charges against your client. Maybe to put my question clear, do those other cases have any bearing on whether or not the accused persons are guilty of the offense before us? Or does it affect the fairness of this trial, the procedure? I just want to understand how that issue arises with regards to the trial which is before.
My lord, on the merits of whether or not they are guilty of
Maybe I've narrowed it too much.
yes, my lord.
Yeah, I want to know how that the failure by ZEC, the alleged failure, let me say, the alleged failure by ZEC to investigate the information arising from the audios and videos impacts on the case before us.
In their minds, my lord, when investigations were instigated, it was not about this case alone. There was another case that was involved.
Yes.
And in their minds, that case is the one that has caused them to be brought before you. So the complaint that they are making is that they are being subjected to this criminal offense unfairly, and that...
Are you saying that they have been prevented from presenting themselves or from... They want to be investigated?
They are law-abiding citizens, yes?
Yes.
They will not refuse to
So
be
how does that
investigated.
concern us now?
My lord, it then concerns us in that the various, especially the case of Commissioner General of Police versus Renford, it makes it clear that this court can look at the conduct of the police.
Yes, in an appropriate case, in a case commenced for that purpose. We just put cases simply. If somebody complains of being a victim of crime,
Yes,
it is not up to a police officer to say that I do not feel like investigating.
yes, ma'am.
Because that's a constitutional mandate. And that person can then take up that issue with the authorities, and if there is no joy, they can approach the court for whatever relief. That's a separate issue. What I want to understand, at the risk of repeating myself, is how does the failure of the alleged failure of ZAC to investigate them for the other offenses allegedly arising from the videos and audios affect this matter?
Their belief, my lord, is that this case is being it's rather a scapegoat. If one is to go to
you are saying
the
this
issues
case
raised
is fabricated.
Yes, precisely, my lord.
Is fabricated, but is that really a constitutional issue? Is that not a matter for defense?
No, my lord, especially where you then have a constitutional board.
How do I determine that this matter is fabricated without going into the merits?
My Lord, if you may, the submissions that I'm making, my Lord, is that if we are to refer to paragraph K, wherein the referral is being sought, they make it clear that these allegations are being made, the current ones, are being made because they are being punished wrongly, that they are the ones who leaked certain audios and certain videos.
Yes.
And the reason why they are now before you is as a punishment, unjustly so, being meted on them. They believe that there is simply a persecution of their rights, that this is not a genuine offense or a genuine prosecution. It is arising from the audio recording.
So you want the charges quashed. I'm still struggling to get the point, Mr. Mukia. You want this court to find that these charges are fabricated without going into the evidence?
No, my Lord, that's not.
So what exactly is the point? Because if a false allegation is made, the procedure is to inquire into that. It's just a dispute of fact. It's the state allegations. Are the state allegations correct? The state will prove that. They will have to prove that.
No, my Lord, that's not what they are seeking from this court. What they are seeking from this court is a determination of whether or not, from the facts as agreed and from the evidence that they've laid,
Yes.
whether there has been a failure by the Zimbabwe Anti-Corruption to investigate a prima facie offense arising from facts that have led to the arrest. Thank you, my Lord. My Lord, with your leave, if I may then move to the final issue, which is N.
So if there is a failure by ZAC to investigate a prima facie case, these proceedings must be stayed until that matter is investigated. Is that what you're saying?
If this court then finds that there indeed has been a failure, and that as a result of that failure, they have not been accorded protection of the law, then certainly they are then entitled to seek permanent stay. Whether or not the Constitutional Court then agrees with them is something else. But if they believe...
So you are contesting the state... these proceedings are commenced by the state in terms of Section 160.
Yes, my Lord.
Subsection 1.
Yes, my Lord.
Because the state believes on reasonable grounds that there is a case against your clients, a criminal case.
I agree, my Lord.
Yes. So how do you want this court to deal with that? You want me to interdict the state from prosecuting them?
No,
what
my
exactly?
Lord, we're not seeking an interdict. No.
So how does a permanent stay of prosecution arise? If you are not contesting that the state had reason to indict them.
No, my Lord, we're not seeking an interdict before you.
I'm saying not interdict in the strict sense, but in the sense that a permanent stay is an interdict. It's a form of interdict. Whichever way you want to look at it.
My Lord, if you may just be with me. My Lord, I hear you where you say that permanent stay in one way or the other is really an interdict. My Lord, the the issue is really not about, it's about the cumulative effect of these factors. To them, it appears as if there is persecution on their part.
So the cumulative effect of that, you're saying, absolves the accused person of criminal liability. I honestly am struggling to follow.
No.
I have to formulate the issue for determination. That's why I'm asking you to help me, because when eventually I must make a decision.
I hear you,
What am I looking at? Is the allegation that because the Zimbabwe Anti-Corruption Commission has not investigated certain audios, then the accused persons are absolved from criminal liability?
My Lord, those are not our submissions, and that's not the point you are making.
Yes.
My Lord. The point you are making is that
even if the state is correct in arriving at the conclusion that there is reasonable basis to prosecute them, they should not be prosecuted because there is another matter that deserves to be given priority.
My Lord, the issue is about a complaint that has been made by them. If there is a finding that indeed that their rights have been violated with respect to this point, they are entitled to seek permanent stay.
Disabuse me of a misconception, assuming I'm laboring under one. The High Court has jurisdiction to deal with several issues.
Yes, my Lord.
Several concerns, several disputes, isn't it? But this court was convinced, and I'm presiding over a criminal trial, and I must be dealing with issues that are connected to the criminal trial. If the accused persons have got any complaint arising from an infringement of a constitutional right, they can still approach the courts for a remedy, isn't it?
I agree.
Yes. In other words, we should really be dealing with issues that affect this criminal trial. That's my understanding. We can't deal with every complaint which the accused persons have. They probably have many other complaints against the state and perhaps against any other people. You see. Like in this case, they have got a complaint against Zach. Zach is not here. It's not a part to these proceedings. It's not a part to these proceedings. It is not even able to respond to the allegations that you are making. So ordinarily, when you are making a complaint against an entity, it must be accorded the opportunity to respond to such allegations. And there's a way of doing that. I'm not really. So I want to know what issue I'm dealing. Am I dealing with a complaint against Zach? And will this criminal trial be the appropriate forum for me to be dealing with that? Because Zach is not represented here.
My Lord, with respect, I believe that this is the appropriate forum for them to raise these issues. In terms of Section 175, subsection 4 of the Constitution. Because the sequence of events is what has led them to be before you. And they are complaining that in that sequence of events or in those facts that have been outlined, their rights were violated. And I believe that the Zimbabwe Anti-Corruption forms, it's part of the state.
In other words, investigate us for another offense that we may be reasonably suspected of having been committed before you deal with this matter. Is that the point?
No, my Lord. In other words, there is selective prosecution.
In this matter? For this charge? There are so many cases flying about, Mr. Mukia. You want us to pack this case and find out what other cases your clients may be facing and deal with them. The issue, you actually said they are not suggesting that there's any other person who ought to be jointly charged with them in this
Yes,
matter.
ma'am.
Yes. So I'm just saying, is it selective prosecution with regards to this matter or selective prosecution with regards to other matters which are not before me? I'm not seized with every matter in the country arising
hear
from this
you, and
jurisdiction, yes.
I appreciate
And I do
that.
not wish to arrogate to myself jurisdiction over matters that have not been properly brought before me. If if they are saying there is selective prosecution in this matter, then of course that would be of interest to this court. But if it is any other matter, tell me why it should be of interest to me. Why I should exercise jurisdiction over a matter that is not before me. Because as soon as I inquire into that other matter, I'm exercising jurisdiction over that other matter. Why should I do that?
My Lord, I hear you. I've endeavored really to address the court on that point, and I'm unable to take this point further, but my instructions are to insist on that point.
You may not insist.
Are to raise the point, my Lord. I apologize for the language.
Thank you very much. Anything else?
Yes, my Lord, we remain with N. My Lord,
Just before you proceed, I know that you have got instructions, but in all fairness, Mr. Mugia, when I ask you a question, it's because I'm having difficulties in comprehending the point that you are driving at. And over and above the instructions that you have, you have a duty to the law. You cannot just say, I will not assist you. Are your instructions not that you should not assist the court?
No, my Lord.
Yes, you are part of the court. You are part of the discourse. So when I don't follow the point that you are making, because I must at the end of the day, in writing judgment, identify the issue and its relevance to the criminal matter. What you have simply done is to refuse to assist.
No, my Lord. I believe that I've
Very well, it's okay.
I've tried
but I'm
to-
sure
to
you.
address it.
I'm just appealing to the professional in you. In as much you've got interest to protect, we must make sure that we maintain the integrity of our legal system.
I hear you, my Lord.
Yes. Very well, thank you.
Thank you, my Lord. My Lord, if I, with your leave, address you on point N.
Yes.
The point is as follows, my Lord. Whether the conduct of the Anti-Corruption Commission in vetoing the bail consent granted by the Acting Director of Prosecution on the 20th of June 2024 amounted to a violation of their rights to equal protection and benefit of the law as enshrined in Section 56, subsection 1 of the Constitution of Zimbabwe. Number 1 is an accused person as enshrined in Section 50 and 70, subsection 7, subparagraph 3 of the Constitution of Zimbabwe. 2, to equal protection and benefit of the law as enshrined in Section 56, subsection 1 of the Constitution of Zimbabwe. My Lord, I'll start by referring you to the statement of agreed fact.
Yes.
Paragraphs, the court may just bear with me, paragraphs 11 and 12. And it reads as follows. On that same date, the 26th of June 2024, when the accused persons arrived at the Criminal Magistrates Court, the state, through the Provincial Public Prosecutor, consented to bail, and this consent to bail was issued in the presence of Henry Chapkanya, a representative of the Zimbabwe Anti-Corruption Commission, who did not object to the Prosecutor General consenting to bail. Paragraph 12. Thereafter, Mr. Michael Reza, a former public prosecutor and now the current chairperson of the Zimbabwe Anti-Corruption, later arrived at court and held a meeting with the provincial public prosecutor, the result of which was that the state withdrew the consent and was now opposed to bail. My Lord, I've read the response by the state, wherein the state affirmings are that the cancellation of the consent was of no bearing to the accused persons being admitted to bail. It still remained the discretion of the court whether or not to then admit the two accused persons to bail. My Lord, that is not the complaint being made by the accused persons. The complaint is that there has been interference with a quasi-judicial decision that had been made.
There was interference?
Yes, that is the complaint.
With a quasi-judicial?
Decision that had been made by the provincial public prosecutor. And that this interference amounts to a violation of their rights in terms of the right to equally benefit and to be protected by the law. The point, my Lord, is that a public prosecutor must exercise their rights independently and may not be subjected to any external pressure. And I think there are several cases regarding to that point, including State versus Sivan and another, Harare High Court, judgment number 320 of 2023. It's your own judgment, my Lord. As well as in Prosecutor General, Constitutional Court of Zimbabwe, judgment number 13 of 2017.
Is it CCZ or SC?
CCZ, my Lord, 13 of 17. My Lord, there is another very interesting case, that of the Zimbabwe anti-corruption versus the clerk of court and others, Harare High Court, judgment 756 of 2022. In that judgment, my Lord, the court...
Oh, sorry to interrupt. How much time do you require?
Less than 5 minutes, I'm almost done. In that judgment, my Lord, the court went to greater lengths to explain the various duties of constitutionally made bodies, and went on to rather express its displeasure at the conduct of the Zimbabwe Anti-Corruption Commission in interfering with the decisions made by other constitutionally made bodies. And this is precisely the point that we make, my lords, that the consent that had been made by the provincial prosecutor had been made after representations or consultations had been made from the investigating officer who represented the Zimbabwe Anti-Corruption. And at that time, the Zimbabwe Anti-Corruption were not objecting to bail. My Lord, if one is to go through the record of proceedings that was uploaded, which forms part of these proceedings, a reading thereof will reflect that initially, when the consent to bail was given, the Zimbabwe Anti-Corruption was not opposed to bail. The opposition, or rather the consent, was then revoked after intervention of the chairperson of the Zimbabwe Anti-Corruption. And it is that intervention, my lord, which we are complaining about, to say that it was unlawful and it resulted in the violation of the rights of accused persons. My lord, unless you want me to address any other point, those will be our submissions.
Thank you.
My lord, I will defer to my colleague. I believe there was an issue that you wanted to address the court.
How much time do you need, Mr. Stu?
Lord, I think it's just 2 minutes. My Lord, the authorities that the point was argued by Mr. Madrid, but I just wish to place them on record, is the one that we've been able to find. The leading one is from South Africa, S versus Malindi. Malindi.
Yes.
Malindi. 1990, Volume 1, South African Law Reports, page 962. A, brackets, an appellate judgment. And then there is K, I think it's State versus K, 1997, Volume 1, South African Criminal Law Reports, page 106, and in brackets C. My Lord, I just wanted to make this distinction as the court will see, as we have also observed. The point is one which has not really been dealt with in this jurisdiction about the substitution of assessors where trial is not commenced but in criminal proceedings. So even in State versus Malindi, it was dealing with in Malindi, they deal with a recusal application which had been made in respect of an assessor. That's the difference. It was actually an application to recuse an assessor. And then when you consider that judgment also, my Lord, it was dealing in the context of when trial had already commenced. So there is no real pronouncement in respect of our jurisdiction on where trial is not commenced per se, but during criminal proceedings leading into a trial. And what we urge the court is to then take it then speaks of a general position that when it comes to the removal of an assessor, there has to be that Audi pattern, Audi Alternate pattern rule to be observed in respect of the accused persons. So I just thought I should be forward to the court, but it's not on all fours, but it deals with principles that apply, and we submit that then that be applicable in our circumstances of the case. Beyond that, Lord, those are our submissions.
Did you find the judgment by Justice Chitabi?
No, if I can, I just inquire from. Lord, we haven't been able to find that judgment, but what we understand is that the Concord then struck off the application itself.
Oh yes, I'm aware. So you
we haven't been able to find
it may not really be in that event. It may not be very useful, is it? Because it was not confirmed, is it?
Indeed, Lord. Indeed. Lord, unless there are any other issues, those are our submissions. Most of it.
Yes, I propose that we take the tea break now. And resume at 12:30. I see it's 7 minutes to 12. We can resume at 12:30. Will you be ready to respond, Steve?
Indeed, my lord.
Very well. So we resume at 12:30. The court will adjourn.